postmarked the Durham address. Ms. Mangum has not been confined here in Durham. Everything comes bearing his association's label. It's called Justice for Niphon. Most of what has been filed in this case has indicated that he is acting as a courier for her. And we believe that he's in violation of that injunction that was entered by the Wake County Superior Court Judge on February 18, 2013. So we would object, I would object, and I'll defer to my co-defense counsel.
Your Honor, on behalf of the Durham District Attorney's Office, we would also object under Rule 56 as well. I do not believe it's proper to offer affidavits in support of a motion for summary judgment, but calling a live witness, I would object, is not proper under the rule in and of itself. And as to our belief that Mr. Haar has been acting on behalf of the plaintiff in this action, that is supported by statements that are contained within items that have been filed within the court. I plan to address some of that in responding to Ms. Mangum's motion for summary judgment as well as the motion for default against my client, because it does, within the response to the motion that I filed in opposition to those, there are statements where Mr. Haar, well, within that response, it states in the response that Mr. Haar has gone to the clerk's office, he's making inquiries, he went and filed the actual response for the motion for default against the Durham District Attorney's Office and the motion for summary judgment, that he was the one who was effecting service or attempting to serve my client on behalf of that. So would have, if you would like the more information on that, I would be happy to go into the details, but on the point of having him called as a witness to testify, we would object to that.
Ms. Mangum, the court has previously issued an order permanently enjoining Mr. Sidney B. Haar from engaging in or aiding and abetting others in the acts and activities constituting the practice of law. And by your own statements, he has in his possession certain documents that apparently have been assisting you in preparation for hearing, and the court will sustain the objection of the defendants herein. Do you have affidavits, however, pursuant to the rules that you'd like the court to consider in support of your motion?
I have exhibits that I would like to present.
All right. Do you already have those exhibits available?
Yes.
Mr. Sheriff, if you will assist her.
Each.
Yes, sir. Thank you. Maybe at ease. I'm just seeing these for the first time, and I want to have an opportunity to review them. You can have a seat.
Okay.
Well, I could just tell from the very first page, ma'am, the caption in and of itself reads, in part, exhibits by Sidney B. Haar, lay advocate, Committee on Justice for Mike Nodbaum. And the court has already enjoined such pleadings from this particular person. Do you have any other affidavits, to submit to the court in support of your motion?
No, I do not.
Is there anything else you want the court to consider regarding your motions before the court today?
Yes. I'd like to file a motion to have, because investigator Marion Bond was the only witness to testify before the grand jury, and because I was found innocent of the larceny and chosen action, I would like to order for the 18-page report of Dr. Clay Nichols to be revealed. It was deemed relevant to my case on November of 2012. My attorneys got a chance to see it. I've never had a chance to view it. Also, I'd like to file a motion to be released on my own recognizance because Bond was the only witness to testify before the grand jury. The malicious prosecution charge, she's found guilty of that, then I would ask for a new trial.
Is there anything else, Pam?
That's it.
Thank you. You may be seated.
Mr. Hart, have a seat.
Sir, you may not.
Have a seat.
Just so that we're all clear, if you are not an attorney representing either of the parties present, you will not be allowed to speak out in court. The deputies will escort you out of the courtroom so you're not disrupting court. Thank you for your attention to these matters. In response to the motion, Counsel?
Thank you, Your Honor. Again, Kim Rayburn from the Durham City Attorney's Office. In response to Ms. Megan's complaint in this action, I actually filed a motion to dismiss on behalf of Officer Bond, now Captain Bond. And so that motion was also noticed for today. May I present my argument in that name? Thank you. I'd like to take a second just to give you a factual context for this, if you'll just indulge me for a minute. There is a lot in the paperwork that we've seen, and for instance in the exhibits that were handed up, that relates to justice for knife bomb and underlying criminal action that's not related to this civil claim. Taking the facts in light most favorable to the plaintiff, which we are required to do, and indeed in the manner in which she has pled them, I will acknowledge that plaintiff is, of course, widely known to many people as a former dancer and North Carolina Central University student who alleged that she was assaulted by members of the 2006 men's Duke lacrosse team at a house party on March 13, 2006. And on the basis of her allegations, there were 3 members of that athletic team who were indicted for sexual assault. But after extensive investigation and prior to a trial of those criminal charges, they were dropped entirely by then Attorney General Roy Cooper, who declared the men accused completely innocent, dismissed the criminal case in its entirety. And I start with this history only because, again, the plaintiff's motion for default and summary judgment, as well as plaintiff's responses in opposition to each of the defendants' dispositive motions, make reference to that history and to the various underlying events and theories surrounding what's commonly known as the Duke lacrosse case. So I just wanted to make that point. I also want the court to know that we do acknowledge and understand that she's grounding much of her grievance in the present case in that history, and it's kind of being spun as a retaliation case, so to speak. That said, this case is not about the Duke lacrosse case, and her claims in this case, which has been brought against Mary Ann Bond and against the Durham District Attorney's Office, do not share that history. Instead, this case stems from plaintiff's trial for theft from and the murder of her then roommate and intimate partner, Reginald Day, a trial that occurred more than 7 years after the events underlying the Duke lacrosse case. So just a brief summary of the events that are pertinent to this action. In February of 2011, plaintiff met Reginald Day when he worked on a painting crew that was painting a room in the residence of a friend of hers. She was staying at the home. In March of 2011, because she needed somewhere to live, plaintiff and her 3 children moved in with Mr. Day into his apartment at Country Scene Apartment Complex. Within weeks of plaintiff moving in with Mr. Day, they had become intimate partners, and that can be found in her complaint in paragraph 35. On March 27, 2011, Mr. Day gave to plaintiff a cashier's check made out to Country Scene Apartments in the amount of $300. which showed him as the remitter and payer of the check. And on April 1st, 2011, Mr. Day gave plaintiff a second check, this one in the amount of $400, but still showing him as the remitter payer of the check. And the check was made payable to Country Scene Apartments. Plaintiff had accepted both of the checks, put them in her purse, and agreed with Mr. Day that she would deliver them to the apartment manager on April 4th, 2011 as payment for their April rent that year. Due to the subsequent circumstances, those checks... Due to the subsequent circumstances, those checks actually stayed in her purse and they were never delivered to the apartment complex. On April 2nd, 2011, plaintiff and Mr. Day went to a party at the home of a relative of Mr. Day, and they returned to their apartment in the early morning hours of Sunday, April 3rd, 2011. Plaintiff and Day then got into an argument and then into a physical altercation, which plaintiff describes in some detail in the complaint, that presumably stemmed from flirtation and, as she characterized it in the complaint, jealousy on Mr. Day's part. And that altercation culminated with plaintiff poking Day in his left side with a steak knife. Day reported ambulances were called, 911 was called or whatever. Day reported to first responders that arrived on scene and also to his nephew, who lived in the same apartment complex, that plaintiff had stabbed him and stolen his money. So that is pled in her complaint in paragraph 50. Mr. Day was then later admitted to Duke Medical Center, where he was transported to the medical center from that scene, where he underwent several medical procedures related to his wounds. On April 4th, my client, Captain Marianne Vaughn, who was then a detective who had been assigned the case, the assault with a deadly weapon with intent to kill case, went to speak with Mr. Day in the hospital. He was still alert and cognizant and aware and able to engage in conversation. And she interviewed him at some length. From that interview, she did generate a report, which plaintiff has referenced in several of her filings. And that report is referenced in complaint in paragraph 53 and also in Exhibit C to her complaint. Mr. Day then declined, his condition deteriorated, and he died in the hospital on April 13th of 2011. On April 14th of 2011, a deputy chief medical examiner performed an autopsy and determined and reported that Day had died secondary to complications of a stab wound to the chest. That is in her complaint in paragraph 58. And on April 18th, 2011, the Durham Prosecutor's Office went before a grand jury seeking an indictment of plaintiff on first-degree murder of Reginald Day and also on 2 counts of larceny of chosen action for the 2 cashier's checks that were in plaintiff's purse. Officer Vaughn did testify before the grand jury. The grand jury returned the indictment for the 3 charges sought. Plaintiff was tried for these charges in November of 2013. The jury returned a verdict on November 22nd, 2013, finding plaintiff guilty of the second-degree murder of Reginald Day and not guilty of the 2 counts of larceny of chosen action. So, fast forward to today, this lawsuit was then filed against Marianne Vaughn in her capacity as a detective for the Durham Police Department that was investigating the assault and later death of Reginald Day, and the Durham District Attorney's Office for the charges that they brought against Ms. Mangum and the trial on those larceny charges specifically. This complaint was filed on January 2nd, 2018. The action is styled as one for malicious prosecution under common law, and plaintiff asserts that both defendant Bond and defendant Durham District Attorney's Office knew that Day gave her the cashier's checks to hold to pay the rent, and that based on Mr. Day's statements to Officer Bond in the hospital on April 4th, 2011, they could not have reasonably believed that she had committed larceny of chosen action. So that's the basis of this lawsuit, is that they should not have brought those charges because Day had said to Bond, well, I gave them to her, but I need them back. He had also said in that report, if you look at the police report, that she had taken his money. He had also reported, according to her complaint, to his nephew and to the EMTs on scene, that she had stolen from him. So there were a lot of mixed statements coming from Mr. Day. But the bottom line is she's premising this entire lawsuit on the fact that she was acquitted of the larceny of chosen action charges on November 22nd, 2013. This action was not filed until January 2nd, 2018, which obviously, on the face of all of the pleadings, is not within a 3-year statute of limitations for personal injury to the plaintiff. You know, North Carolina General Statute 1-52, paragraph 5. This is not in compliance with a timely filing. And so I'm going to keep it very, very simple. Initially, we had filed a motion to strike because of the nature of the complaint. It has lots of exhibits that entail communications that Mr. Haar has written to the governor and to now Attorney General Josh Stein, and newspaper articles and all sorts of ancillary information that is not pertinent to the underlying claim. Bottom line, this is an untimely filing, and her claim should fail because they were not filed within the 3-year statute of limitations. And I think just in the interest of judicial economy and to keep this as clean and simple as we can, that is the argument that I'm going to put before the court, and I ask Your Honor to consider that.
Yes, ma'am.
Your Honor, again, my name is Catherine Shields. I'm an attorney at the North Carolina Department of Justice, and I'm representing the Durham District Attorney's Office, who is also a defendant in this action. Your Honor, also before the court today, we briefly talked about this earlier, but Ms. Mangum filed a motion for default against the Durham District Attorney's Office, as well as the motion for summary judgment. I filed a response in opposition to both of those motions and calendared that for hearing today. And I also filed a motion to dismiss on behalf of the Durham District Attorney's Office. I will not go back into the history or the facts of this case as they were presented by Ms. Rayberg, and I will just get to the meat of the motions that I have filed, if that's all right.
You may proceed. Yes, ma'am.
In relevant part to the motion for default against the Durham District Attorney's Office, I'll just briefly go back through the facts as to the filings and why that motion should be denied. The plaintiff filed this complaint on January the 2nd of 2018, and she, on the summons issued in conjunction with that complaint, the filing of that complaint, it listed that the service should be made on the Durham District Attorney's Office at 510 Dillard Street, 8th floor in Durham, North Carolina, which is the location of the Durham District Attorney's Office here in this building. Then the plaintiff attempted to serve process via certified mail return receipt requested to the Durham District Attorney's Office at that address. Jumping forward to March 8th, 2018, the plaintiff, via Mr. Haar, writes in that motion for default that based on no return of service ever being returned, even though they purport to show that they've tracked on a UPS tracker that something was delivered to a front desk here in this building on January the 5th. Jumping forward to March the 8th, Mr. Haar went to the clerk's office to file the motion for default and summary judgment, and learned there that the clerk's office did not consider the Durham District Attorney's Office to have been served at any point in time. Then on March the 26th, the plaintiff had an alias and plurries summons issued to the Durham District Attorney's Office. That summons also showed that service should be made at that same address, 510 Dillard Street, 8th floor here in this courthouse. That time, the summons and complaint were given to the sheriff for service of process, and there is in the court file, after I obtained a copy of it, something showing service on the DA's office back on March the 28th. But in that, I would submit that in order for this court to enter a default or grant the plaintiff's motion for default, service must be done in compliance with Rule 4J4, Part C of the North Carolina Rules of Civil Procedure. And that statute specifically states that when a state agency, such as the Durham District Attorney's Office, has not designated an agent for service of process, that service should be made on the North Carolina Attorney General's office or on to an assistant attorney general or a deputy attorney general, such as a special deputy or senior deputy attorney general. So even in trying to serve the Durham District Attorney's Office via having service made by the sheriff here in this building, service has not been achieved in compliance with Rule 4J4C of the North Carolina Rules of Civil Procedure. And as such, the District Attorney's Office has not been served in this action. And if the District Attorney's Office has not been served, this court does not have personal jurisdiction over them. So an entry of default would not be proper. For the same reasons that Ms. Freyberg mentioned in responding to the motion for summary judgment, we too contend that this action, which is an action for malicious prosecution under the common law, is barred by a 3-year statute of limitations that is in North Carolina General Statute 1-52, Part 5, which is a 3-year statute of limitations. In moving to the motion to dismiss, the motion to dismiss that I filed on behalf of my client was on the basis of insufficient service of process, which I've just talked with you about, lack of personal jurisdiction. I also moved to dismiss the action based on the statute of limitations, and the only thing that I have left to add is that, as you are probably aware, the state of North Carolina, in order to bring a cause of action against the state of North Carolina, the state must give its consent to suit. The state, there's a doctrine, that's the doctrine of sovereign immunity, and it merely states that sovereign immunity grants the state, its agencies, and its officials who are sued in their official capacities an unqualified immunity from suit unless the state waives that immunity expressly via statute or it consents to the suit. That has not been done in this. The state has not waived its immunity for a state agency or a state official in their official capacity to be sued for malicious prosecution. Also, in order to breach, even if the state had waived its immunity via consent or a waiver, the complaint must also expressly allege a waiver of the state's sovereign immunity. And this complaint does not contain such waiver. So, Your Honor, we contend that the plaintiff's claims are barred by sovereign immunity against the defendant, Durham District Attorney's Office. And that's all I have, unless you have some questions for me.
Any final arguments in response, Ms. Mayor?
Yes, Your Honor. First of all, I'd like to address attorney for Marion Bond on the statute of limitation argument. There's an article under the NCGS. It's Article Article 5, 152-9 says that an exception can be given where there is a case of fraud or mistake for the statute of limitation. I was under legal counsel for the 3 years, the 3-year time frame that they're referring to. I depended on my attorneys to represent me. At that time, they were not acting in my best interest. I filed several complaints against my attorneys with the North Carolina Bar Association during that time as well. For that reason, I think that the statute of limitation issue should be waived under Article 5, 152-9. Concerning the issue of, or the argument of incomplete or lack of service, I do have a document here that shows the UPS tracking system where the summons was mailed to the district attorney's office, and they did receive it on January the 5th, 2018 at 1:56 p.m. I have the tracking history here. They received it and they signed for it. They also defaulted on a response for my motion of summary judgment. And for that reason, I'm asking that my motion of summary judgment be granted. There is no dispute as to the germane facts of this malicious prosecution complaint. They're arguing on the defendants are arguing on technicalities, and I'm arguing on the merits of the case, which are that the 4 elements for malicious prosecution are met, which are lack of probable cause. The defendant initiated the charge. There was malice involved, proven by the lack of probable cause, and the outcome was favorable to myself, the plaintiff. That's all.
Thank you. Final arguments from our opposing counsel before I rule.
Your Honor, with respect to the statute of limitations issue, I understand that plaintiff is contending that she was defrauded by and did not receive effective assistance of counsel from multiple levels of attorneys, both at trial, her appellate counsel. I believe North Carolina Prisoner Legal Services has also been implicated in some of what she's filed, and she's contending that all of those attorneys did not alert her to the fact that she potentially had a claim for malicious prosecution for the 2 charges of larceny of chosen action. And if there was an issue of fraud, it certainly wasn't on the part of Captain Bond defrauding her, which led to her losing her right to sue. It sounds like what she's painting is a portrait of someone who contends she has an ineffective assistance of counsel case. I would say that if the state bar, she has filed multiple actions against different attorneys who have represented her in this criminal case. The state bar has declined to discipline any of those attorneys. It would be one thing if the state bar had indicated that the attorneys had not provided effective assistance of counsel to her or had engaged in some sort of malfeasance that did jeopardize her legal interests, but that's not the case. And given that, I would say, to Your Honor, the statute of limitations is the statute of limitations. There's no showing of fraud or misrepresentation on the part of my client. And any mistake of her rights cannot be attributed to Captain Bond. I'd like to point out, too, this is a little bit outside the scope of what we've been talking about. I wanted to keep it simple and talk about the statute of limitations because that is the clearest, simplest way without us having to get deep in the weeds of what's been alleged. But the allegation against Officer Bond is essentially that she knew that Reginald Day had given plaintiff the 2 cashier's checks. Plaintiff also alleges that that appears in Officer Vaughn's report. Plaintiff alleges that Officer Vaughn testified before the grand jury, and plaintiff alleges that Officer Vaughn testified at trial to the fact that at some point Reginald Day had told her that Reginald Day gave the checks to Ms. Mangum. There is no allegation in this complaint that Officer Vaughn modified her report, falsified a report, hid the report, didn't turn over all of her investigatory findings to the district attorney or to the grand jury. There's no allegation that would support the malice prong, for instance. So I'm getting a little confused at some of her arguments. But all of that to say, I would just ask Your Honor to please dismiss this case with prejudice as to Police Captain Marianne Bond. I would also ask, and I think it's important in this instance, that the court take notice of the injunction that has been previously entered in Wake County regarding how the plaintiff is filing these materials against multiple defendants. This has been a problem at both the state level and the federal level. I know that Duke University has had a number of issues with filings on Ms. Mangum's behalf, and they have obtained injunctions from courts, from the federal court specifically, most recently in 2016. Obviously, the North Carolina State Bar has taken notice of some of this activity, so that I would ask, Your Honor, if you do rule in favor of the defendants, that you also enjoin plaintiff from continuing to file actions, certainly against Officer Bond, but against other members of the Durham Police Department through the efforts of Sidney Harr. Thank you, Your Honor.
Thank you. Any final arguments from counsel?
Your Honor, I would just briefly like to respond that Rule 4 of the North Carolina Rules of Civil Procedure, Rule 4J4 Part C, is very specific in that when there's not an agent for service of process for a state agency, service of process is to be made on the North Carolina Attorney General's office to a deputy or an assistant attorney general. That did not occur in this case. When the Durham District Attorney's Office reached out to me, they first provided me with a copy of the motion for default and summary judgment. To this day, we have not found the summons and complaint that was delivered to the front desk upstairs. Service is supposed to be was supposed to be accomplished to conform with the rules. That was not done here. We'd ask that you dismiss this action with prejudice for the reasons previously stated. Thank you, Your Honor.
In the matter of Crystal Gail Mangum, plaintiff pro se versus Marion Bond, officer of Durham Police Department, and the Durham District Attorney's Office, the complaint filed herein on January 2nd, 2018. Now, coming before the court pursuant to motions filed by the plaintiff, to wit, motions for default judgment and motion for summary judgment. After considering the evidence, the arguments of counsel, as well as the verified pleadings herein, said motions are hereby denied. In response to motions filed herein, the defendants filed motions to dismiss, the first ground being insufficient service of process, lack of personal jurisdiction resulting therefrom, and the issues of statute of limitations, and also the pleadings are barred because the improper defendants were listed and served. The court respectfully grants the motions Ms. Mangum to dismiss your complaint herein for untimely filing. There's been no showing of fraud, any misrepresentation as the exceptions that you've argued before the court. And on both counts, the motions to dismiss are hereby allowed with prejudice. Because also in your filing today, you attempted to submit to the court's attention some exhibits involving a Sidney Harr and the nature of the allegations therein and continued pleadings filed, I am now issuing what we call a gatekeeping order that will enjoin such filings or pleadings in the future against the District Attorney's Office and or the Durham Police Department. Is there anything else that came to the court's attention in this matter? No.
I would like to appeal.
The plaintiff in this matter gives notice of appeal in open court. Yes, ma'am? Anything further from the defendant?
Nothing further from defendant Bond, Your Honor.
Nothing further, Your Honor.
Thank you. That concludes this matter.
Sir, have a seat.
Madam Clerk, is that clear our docket for this?